Good evening. My name is Juan Thomas, and I'm an of-counsel partner at the law firm of Quinteros, Prieto, Wood, and Boyer in Chicago. And I have the privilege of serving as one of the co-chairs of the board of directors of the Chicago Lawyers Chapter of the American Constitution Society. I want to welcome all of you tonight to our virtual platform to learn about the coordinated, dangerous, and misguided effort to alter our United States Constitution through an Article 5 convention. Tonight, you will hear from a distinguished panel who will explain to us how special interest groups are attempting to use this provision to force Congress to authorize a convention to rewrite the Constitution. We are grateful for their time and their expertise. I also want to thank our co-sponsoring chapters. Of course, my chapter in Chicago, but also New Jersey, New York, Oregon, Puget Sound in the state of Washington, and Washington, D.C., Lawyers Chapter, and of course, the Rutgers Law School Student Chapter in New Jersey. We thank you for your sponsorship and your participation. For those of you who are new to ACS, the American Constitution Society is the country's foremost progressive legal organization with more than 250 students and lawyer chapters across the country. ACS is a nonprofit, nonpartisan 501c3. This year, ACS is celebrating the 20th anniversary of shaping national legal debates, nurturing the next generation of lawyers, judges, scholars, advocates, and working to ensure that the law is a force to improve the lives of all people. We are dedicating this anniversary year to race and the Constitution and the reckoning with the past for a more just and equitable future. Now, I have the high honor of introducing someone who needs no introduction to ACS. Can you name that guy who started off as a state senator, then became a US senator, and now we call him Mr. President? No, not that guy, the other guy, President Russ Feingold, who will provide an introductory remarks on today's panel discussion. Mr. President, the floor is all yours.
I'm trying to get my video. There we go. Juan, all right, that was some introduction. I loved it. And you are one of the really great leaders of this organization across the country. I want to especially thank the Chicago chapter for taking the lead on this. Thank you so much, Juan.
Thank you, sir.
Welcome to everyone joining us this evening for this important conversation about Article 5. We are witnessing a constitutional crisis right now with a Supreme Court that is no longer fulfilling its mission of upholding our most basic constitutional rights. The legitimacy of our democracy is more and more questionable as more states pass horrific voter suppression laws, doing everything they can, it seems, to make voting nearly impossible for many people. The First Amendment is being weaponized by the right to go after workers' rights and other core democratic principles. Given such constitutional chaos, it is fitting that we are coming together tonight to discuss Article 5, which specifies how our Constitution can be amended. It is particularly fitting because the constitutional chaos we are experiencing is being used as cover by special interest groups to call for an Article 5 convention, glossing over the even greater danger to our country and our constitutional democracy that a convention could cause, at least if it is unlimited in scope. The right undertook a successful multi-decade campaign to pack our courts and gain control of our highest court. We are now seeing the right undertake a not dissimilar campaign to build a case for an Article 5 convention, at which they could propose any array of destructive amendments with the real possibility of securing their adoption. I am afraid to say that progressives are playing catch up when it comes to our judiciary. ACS is advocating strongly for Supreme Court reform. We are also actively recruiting diverse qualified candidates for the bench and working with the White House to undo the rights packing of our courts, but it will take time. We cannot afford to be caught on our heels when it comes to an Article 5 convention. There are so many unanswered questions. I've done some teaching on Article 5, and I know that at the Constitutional Convention a while back, the one in 1787, even James Madison bemoaned that there were so many questions about this Constitutional Convention provision. So at ACS, we believe these questions have to be seriously considered. Now, in fairness, there are credible people on the left who also support a constitutional convention to address progressive priorities. Well, I think many of us share the desire to remedy certain constitutional challenges, such as the Supreme Court's egregious decision in Citizens United. This event will be an opportunity to explore why a convention may not be the answer it seems at first. And it is something that I think we need to be discussing over time. I am grateful to our moderator and our panelists for lending their expertise today and for helping explain why an Article 5 convention is such a consequential possibility. So with that, I'm happy to turn things over to Karen Hobert Flynn to moderate this timely and important panel. Karen?
Thank you, Senator Feingold, and it is my honor to be here. I am Karen Hobert Flynn, president of Common Cause, and I'm really looking forward to the discussion tonight. Common Cause has long been involved in the issue of Article 5. The goal of tonight's program is to educate participants about the Article 5 and engage a community of legal scholars and advocates. This conversation and the American Constitution Society is a 501c3 nonpartisan educational organization and does not lobby. And so this event will not be encouraging lobbying, but actually more education around the dangers of an Article 5 convention. So I'm going to start by introducing our distinguished panel and then turn it over to each of them for their opening remarks. And then we will take your questions. So as you are listening to them speak, I urge you to put questions in the Q&A, which you'll see at the bottom of your screen. So first I'll go through all the introductions and then we'll turn it over to our speakers. Our first speaker is Wilfred Codrington, Assistant Professor of Law at Brooklyn Law School and Fellow at the Brennan Center for Justice. Professor Codrington is a constitutional law scholar with a focus on constitutional reform, election law, and voting rights. He was previously the Bernard and Ann Spitzer Fellow and Counsel at the Brennan Center for Justice at NYU School of Law, where he focused on voting and election security, constitutional reform, and the rule of law. He is the co-author of the forthcoming book, The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union, which examines the history of constitutional amendments and the tension between the overall progressive arc of constitutional change and the conservative grip on the broader conversation around the Constitution. Previously, Professor Codrington was an associate at DLA Piper in the Litigation, Government Investigations, and Regulatory Practices, where he participated in a variety of pro bono projects on behalf of individual clients, minority communities, and nonprofit organizations. He also clerked for the Honorable Deborah Ann Batts, U.S. District Judge for the Southern District of New York, and served as a staffer for U.S. Congresswoman Eleanor Holmes Norton. Our next speaker will be Carolyn Shapiro, Professor of Law and ACS Faculty Advisor at Chicago-Kent College of Law and member of the ACS Chicago Lawyer Chapter's Board of Advisors. Professor Shapiro is the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States. Her scholarship is largely focused on the Supreme Court, its relationship to other courts and institutions, and its role in constitutional democracy. From 2014 through 2016, Professor Shapiro took a leave of absence from Chicago-Kent to serve as Illinois Solicitor General. She also blogs frequently at iSCOTUS Now and on the Chicago-Kent faculty blog and CK Now, as well as the Huffington Post and as a guest blogger at the American Constitutional Society blog. She was a law clerk for then Chief Justice Richard Posner of the U.S. Court of Appeals of the Seventh Circuit and for Justice Stephen G. Breyer of the United States Supreme Court. Our third speaker who will be speaking tonight is David Super, Carmack Waterhouse Professor of Law and Economics at Georgetown. David Super's research focuses on administrative law, constitutional law, legislation, including the federal budget, local government law, and public welfare law. He teaches in these fields as well as many first-year subjects and has also taught law besides at Georgetown at Columbia, Harvard, Howard, Maryland, Penn, Washington, Lee, and Yale. And prior to entering the Legal Academy, he served for several years as the general counsel for the Center on Budget and Policy Priorities. Our last speaker, who will be joining us a little bit later, is Aziz Huq, who is the professor of law at the University of Chicago Law School and member of the ACS National Board of Directors. He works on topics ranging from democratic backsliding to regulating artificial intelligence. He is a scholar of U.S. and comparative constitutional law, and his scholarly work is published in several books and in leading law reviews, social science, and political science journals. He has an active pro bono practice and is on the board of the New Press and the ACLU of Illinois. Before joining the law school faculty, he worked as counsel and then director of the Brennan Center's Liberty and National Security Project, litigating cases in both the U.S. Court of Appeals and the Supreme Court. He was a clerk for Judge Robert D. Sack of the U.S. Court of Appeals for the Second Circuit, and then for Justice Ruth Bader Ginsburg of the Supreme Court of the United States. So as I said, he'll be joining us a little bit later. So first, I'm going to turn it over to Professor Wilfred Codrington.
Thank you. Thank you, Juan, for your opening. Thank you, Senator Feingold, for this great session and your continued attention to these weighty questions. Karen, for agreeing to moderate this panel, as well as your organization's work to reduce the threat of an Article 5 convention. And of course, thank you to the rest of the panel. I am the most junior scholar up here, so I really appreciate engaging with such an accomplished group of legal scholars whose work I admire so much. So I'm going to talk a bit to provide a little historical context for Article 5, which is, of course, our Constitution's amending provision. I, along with my co-author, we highlight some of this history, as well as some of the current convention efforts in our new book, The People's Constitution, which is slated for release on next Tuesday. Importantly, concerns over amendments and amendability, they were among the most pressing reasons for the Philadelphia Convention, the 1787 gathering where the framers drafted the Constitution. You see, the Articles of Confederation, which was the previous governing charter for the United States, it made amendments nearly impossible. They were possible only upon achieving the unanimous consent of all states. Complete agreement. But on numerous occasions, one state or another would hold out on giving their consent for important changes. And therefore, they thwarted what others saw as much needed reform. So the framers believed that having some amending provision in the new Constitution and one whose requirements were less stringent than unanimity, that was of the utmost importance. And there was some discussion about this at the convention, some back and forth as to the process and to the persons who were going to be involved, but agreement on Article 5 didn't come until the end of the convention, the very end. And the end result was Article 5, what we know today. It establishes two routes for amending the Constitution. We all know the primary route. We know it very well, a vote by 2/3 of Congress, as well as 3/4 of the states. And that can be either state legislators or special ratifying conventions, as was used in the 21st Amendment. A vote by these supermajorities will lead to the adoption and ratification of proposed amendments. And as I said, we're familiar with this because Well, this is the way we got each and every one of our 27 amendments. The alternate route allows for states to petition Congress. If 2/3 of the state legislators do this, Congress must call a convention for the purpose of proposing amendments. Any proposals emerging from this convention would then go to the states for ratification, and upon ratification by 3/4 of the states, it would become a valid part of the Constitution. Now, as Senator Feingold said, there were some serious questions about this approach at the Philadelphia Convention and doubts about including it in the final draft of the Constitution. But those delegates were pretty much ready to go and move on and get the Constitution out to the people for ratification. So all of their protests were effectively dropped. However, it should be noted that some of the very concerns that were raised at that time are among the very reasons why this alternative approach has not yielded a single amendment. In the more than 2 centuries, not a single amendment has come through the convention mode. Yet that was not for no efforts to have a convention. For one, Virginia and New York anti-federalists began pushing for a convention in 1788. The ink of the Constitution barely dried. They were pushing for an effort to overhaul the structure of the federal government. That effort fizzled quickly, but there were even closer calls in history. In the early 20th century, during the Progressive era, a number of state legislators backed a campaign for a convention as well. And they wanted the Constitution to be changed to provide for the direct election of US senators. You see, Senators Feingold's early predecessors, they got their jobs not because they were popular with their constituents and with the people, they got it because they were chosen by state lawmakers. And so over time, the Senate and the state lawmakers who chose its members, they became mired in corruption and corrupted by big moneyed interests. They were often gridlocked and unable to agree on senators and other federal policy. And so to address this, the House of Representatives adopted multiple resolutions to amend the Constitution so that senators would be directly chosen by the people, but the Senate refused to act on this. They refused to even consider these resolutions. Finally, facing various pressures, including a threat of an Article 5 convention, the Senate finally dropped its opposition, and it ultimately backed the 17th Amendment, which was ratified in 1913. There was also a convention effort in the 1960s, and this was in response to the reapportionment revolution. That is the series of cases that established our one person, one vote doctrine, a doctrine which I'm happen to be working through with my students in the election law class this week. In response to that, Senator Everett Dirksen led a stealth campaign for a convention to overturn that series of cases. Dirksen is someone a scholar once called afflicted with bouts of erratic constitutionalism. This was among those bouts. He wanted to return to an unfair system, a system in which states maintained extremely malapportioned legislative districts, a system with sparsely populated rural areas possessing vastly more power than densely populated diversities. And that campaign came within a couple of Article 5 applications to prompting a convention. But that very close effort died when Senator Dirksen also died in 1969. And then finally, there is this most recent call, a convention that many contend is still alive and well today. This is a convention that seeks, a campaign that seeks a convention to propose a balanced budget amendment. This campaign began in the 1970s and it peaked in the 1980s. Like the earlier efforts I spoke about, this campaign came within 2 states of forcing Congress to call a convention. But the potential for a runaway convention pretty much prompted state lawmakers to rescind their applications. But after about a quarter of a century of a lull, particularly in the wake of the Tea Party movement, this effort was rebooted. So now you have an organization called the Balanced Budget Task Force. They're working to persuade a number of states to pass legislation to apply to Congress for convention. And they've been successful to some extent. Today, they purport to have 27 of the 34 states necessary to force a call of an Article 5 convention. There are a couple more modern efforts. I'm sure we'll talk about them later in the panel, but this is the one, this balanced budget effort is the one that is furthest along.
Great. Thank you so much for that historical context. Next up, I'm going to pass it on to Professor Carolyn Shapiro.
Thank you so much. Thank you, Professor Codrington, for such a great historical overview at the beginning, and thanks to ACS for inviting me to participate here. It's possible to think of Article 5 as an attempt to ensure that any changes to the Constitution will require widespread popular support. The problem that I'm going to talk about is the ways in which some of our current anti-democratic, and that's small d, democratic activity undermines that promise that Article 5 provides. There are lots and lots of unknowns about what would happen if an Article 5 convention were called and how it would be called. And many of those unknowns are ripe for exploitation by the forces of entrenchment and democratic suppression, just as we see in activity surrounding partisan gerrymandering, voter suppression, et cetera. And they go hand in hand. So let me explain a little bit what I mean. As you heard, right, it takes 2/3 of the states to call a convention. Right now, there are 30 states whose state legislatures are under total Republican control. One of them is Nebraska, and if you look on Ballotpedia, it'll tell you that Nebraska is a nonpartisan legislature, but if you actually dig any deeper than that, you'll see that its unicameral legislature has a 32-17 majority for the GOP. Now, some of those states, Nebraska probably being one, are in fact heavily Republican, and their Republican-controlled legislatures undoubtedly reflect the overall voter preferences of the voters, a majority of voters in those states. But some of those states involve significant gerrymandering and or voter suppression. So for example, 4 states that I'm sure you've all heard people talk about when we talk about partisan gerrymandering are Wisconsin, Michigan, Pennsylvania, and North Carolina. All of those states voted, have very, at best, evenly split populations between Republicans and Democrats, or in some instances, the voters really overall vote in favor of Democrats, but the gerrymandering is so extreme that Republicans retain not just control, but significant control. Wisconsin being one example. The state house, it's called the Assembly, in 2018, Democrats received 53% of the vote for state assembly and ended up with 39% of the seats. In 2020, they did slightly better, but the Republicans retain a significant majority in the state assembly, which will control redistricting in this next round. There are other states that we all hear about and talk about, like Georgia and Texas, where voter suppression is a significant part of the lay of the land, where keeping people from the polls, we're making it difficult for people to cast votes. Arizona is another example, is going to be a battle we're going to be fighting. And if that battle is if we are unsuccessful in ensuring people's access to the polls, then those legislatures will become increasingly not unrepresentative of the popular will. And you could have, right now we are 3 state legislatures away from the GOP ability to call a convention entirely on its own terms. So you'll be hearing about, right, what does it mean to call a convention, what might happen at a convention. But that's one problem. And then there are other problems. There are problems related to, if there was a convention, how would the delegates to that convention be selected? It's not actually, Article 5 doesn't tell us. Would Congress select them? Would a gerrymandered Congress select them? Would the state legislatures select the delegates, the gerrymandered state legislatures? Would the voters select the delegates? Would they be voting in gerrymandered districts to select the delegates? These are complete unknowns. We do not have answers to those questions, but you can see how there is sort of a domino effect where at each step, there is the possibility that anti-democratic, small d democratic practices will lead to decision-making about and at the Constitutional Convention that simply does not reflect the widespread popular support we'd like to see in any major constitutional change. Similar problems would arise with ratification. It does take more states to ratify than it takes 38 to ratify, so there's a little more space, but of course the same problems arise there. Regardless of whether Congress sends the amendments to the state legislatures or tells the states to convene ratification conventions, so many of the same problems arise again. And the reality is that it might not be possible to undo a convention once it's happened. The 27th Amendment, which is a kind of innocuous amendment having to do with members of Congress' ability to raise their own salaries before an election, was ratified like 200 years after it was originally introduced. It didn't have an expiration date on it, and it just kind of became part of the Constitution. In my personal view, the current attempts to revive the Equal Rights Amendment are misguided, and they're misguided in part for this reason, that it sets a precedent that even when Congress puts a deadline on an amendment, that it lies there as a threat that can emerge at any point. Of course, I'm in favor of the Equal Rights Amendment or the substance of it, but we might not be in favor of some of these amendments that emerged from a constitutional convention. So I hope after hearing this, you may be a little frightened, but you may also be even more motivated to work on some of the democracy reform matters that ACS has been working on, that other parts of that other progressive organizations have been working on as well. Thank you.
Thank you so much, Professor Shapiro, for outlining some of those real challenges that people might not know about if they don't dig deeper. So next up, I'm going to turn it over to Professor David Super. David?
Thank you. Thank you very much. What I want to talk about is an odd but quite scary twist on all of this, which is so-called plenary applications for convention. Just a shade of background building on what Wilfred said earlier. When they restarted the push for an Article 5 convention ostensibly for a balanced budget amendment, a lot of what the proponents were trying to do is use the old applications from states from the 1970s and 1980s. They thought they were sort of starting 2/3 of the way there or something like that, and that they just needed to supplement that. That strategy looked promising for a while, but we've now seen several of those states rescind their old applications. Delaware, New Mexico, Nevada, Maryland, Colorado have all rescinded old applications. And the current website of the Balanced Budget Task Force claims they have 27 states. And proponents of an Article 5 convention for a balanced budget amendment or similar purposes are now starting to say they're not sure that they can see their way clear to 34. They have opponents on the right as well as progressives, and that has had them consistently running into brick walls in states like Idaho. So they've started a new approach, which is, rather than actually persuading 34 states, even counting a number of holdover resolutions from many decades ago, they want to impress into service 6 states that have never, ever supported, I'm sorry, 5 have never supported their proposal, and 1 initially supported it and rejected it. And these are states that passed applications for an Article 5 convention over a century ago for entirely different purposes. There are 6 of them. The earliest is New York State, which passed an application for a convention in the 1780s. They wanted a Bill of Rights. Well, we've got one. We had one without a convention shortly thereafter. Then in 1861, New Jersey, Kentucky, and Illinois said they would be open to a Article 5 convention if it could head off the Civil War. No convention was held. The Civil War occurred. It's been over for a very long time. And then finally, in the early 20th century, Oregon and Washington passed Article 5 applications, hoping, as Wilfred said, for a convention that would call for popular election of senators. We now have popular election of senators. So again, all 3 of these earlier purposes have been resolved, 2 favorably, 1 unfavorably, but those issues are old. The proponents are claiming that these applications, because they were never rescinded, still count, and that they can add them to the 27 new and not so new applications they have seeking a balanced budget amendment in getting to 34. 27 plus 6 gets you to 33. If you look at the map of some of the states that are very, very red and have not passed Article 5 applications, it's pretty easy to see where they could get 1 more state on top of the 27 that they claim, plus these 6. Now, they say these are generic, that these states said, we just want a convention on anything. If you read them, none of them are that way. Maybe the Washington one. The others are very clear. New York says we want a Bill of Rights. The Kentucky, Illinois, and New Jersey say we want to avoid the Constitution, the Constitution falling apart in the Civil War. And Oregon says we want popular election of senators. They did not say they want generic convention, but that's what proponents say. Now you could say, well, that's just a ridiculous argument, and on the merits it is. The problem is that the arbiter of this is a majority of Congress, and not with even involving presidential signature or veto. If Congress flips Republican, if both chambers flip Republican in the midterm elections a little over a year from now, those majorities can decide to count these ancient, unrepealed, so-called plenary applications that aren't plenary at all, and use that plus 1 more state to get to 34 and start an Article 5 convention. Once they do that, it can be for a balanced budget amendment or anything else. It won't be constrained by anything because, of course, they're counting 6 states that weren't even aware of proposals for balanced budget amendment or any contemporary proposals. And once that convention convenes, all bets are off. That is in many ways the most frightening prospect of this altogether scary process of attempting to open up our Constitution to whatever the current majority desires. Thank you.
Thank you so much. And next, I'm going to turn it over to Aziz, who has joined us, and he's going to provide an opposing point of view. So, Aziz, thank you for joining us.
Hi. Let me maybe move myself. I have to apologize. I'm in my office because today is our entering students. Well, it's not a dinner. It's a people stand around in masks and wave water bottles at each other event. I don't know what these are called these days. So I apologize for coming in late, and somewhat different from what Karen just said. My contribution is going to be from a comparative perspective. You've heard a range of experts and scholars on the domestic constitutional law history and politics of Article 5. What I would like to do is to give you a background on the way in which constitutional amendment has been employed globally to reduce the quality of democracy. Now, since 2010, the average quality of democracy at the national level around the world has been falling. And my colleague and I, Tom Ginsberg, have been working on a series of articles and a book called How to Save a Constitutional Democracy that focuses, or that one of the focus thereof is on the mechanisms whereby democratic backsliding occurs. And one of the inferences that we draw from examining backsliding across multiple jurisdictions is that constitutional amendments are persistently employed as an instrument for curtailing opportunities for democratic challenge to incumbent regimes. Paradoxically, it's the very fact that a constitutional amendment is assumed to have heightened democratic credentials that allows an incumbent regime to take advantage of its temporary popularity or to leverage asymmetries in representation as a means of foreclosing future democratic challenge. The most important examples of this phenomena come from Venezuela and from Hungary. And what I'd like to do is to spend time that I have just running through how constitutional amendments were used in those two jurisdictions. So in Venezuela first, Hugo Chavez ran first for national office in 1988 on a, 98, excuse me, on a populist platform of opposition to corrupt and collusive elites. He vowed in a typical statement to, quote, sweep establishment parties from the face of the earth. However, when he came to power, Chavez lacked a legislative majority. Accordingly, he successfully called for a referendum on a new constitution. The new Constituent Assembly that was thereby constituted was dominated by Chavez allies. That assembly closed the existing Congress, purged the judiciary of independent jurists, and appointed a set of new election authorities. The new constitution that emerged from its deliberation eliminated the Senate, banned public funding for political parties, and concentrated power in the presidency. Among its other measures, it replaced a single 4-year term with a 2 6-year limit system of presidential terms. In May 2017, Chavez's successor, Nicolas Maduro, used the same measure, this time to decisively end Venezuelan democracy. Initially, early in 2017, Maduro had tried to use an aligned Supreme Court to shut down the opposition-controlled national legislature. When that failed, Maduro announced a new Constituent Assembly that would have the power not just to draft a new organic document, but also to dissolve all existing public bodies and to convene new elections. He engineered a public vote that provided a legal basis for moving forward with that second assembly, and the actions of that assembly marked the end of Venezuelan democracy. Venezuela, it should be noted, is not the only Latin American country that has seen the abuse of a constituent assembly. Both Rafael Correa in Ecuador and Evo Morales in Brazil have also relied upon extensive constitutional amendment as an opening gambit in a process of democratic erosion. Pedro Castillo, the incumbent president just elected in Peru, has deepened the sense of political crisis there by suggesting that he's going to hold a constituent assembly along the same lines. Let me turn now to Hungary. In Hungary, Viktor Orban and his Fidesz party exploited a brief moment of supermajoritarian control of the legislature a moment that was abetted by a serious seat vote bias in the electoral system, to adopt a new constitution in 2011. The new Fidesz constitution entrenched that party's position in power. It altered the composition and the operation of the Constitutional Court. It created a new national judicial office staffed by Fidesz loyalists with responsibility for firing and hiring judges. It also strengthened the Prime Minister's authority over the Election Commission, the Budget Commission, and the Media Board. The judicial retirement age was reduced from 70 to 62, and the new National Judicial Office was thereby handed a large number of judicial vacancies to fill in a very short period of time. Finally, the Constitution announced new rules adjusting electoral districts in ways that made Fidesz harder to dislodge in the future. Indeed, Fidesz remains in power in Hungary, notwithstanding a considerable loss in financial support. Hungary and Venezuela are probably globally the two most important examples of how constitutional amendment regimes can be manipulated and violated wholesale. It's worth saying that if one looks beyond those examples, there are many instances in which the constitutional amendment process has been focused on term limits. So in Sri Lanka, for example, President Mahinda Rajapaksa engineered a constitutional amendment in 2010 that allowed him to run again in 2016. And we've seen parallel moves dissolving constitutional term limits from Azerbaijan to Uganda. So whereas in an earlier era, a president that didn't wish to be constrained by a constitutional term limit would simply ignore that term limit. Since 1989, we've seen about 3 out of every 4 efforts for presidents to entrench themselves for life proceeding through term limits to constitutional, proceeding through amendments to constitutional term limit provisions. So these experiences in conclusion suggest that constituent assemblies and like bodies should not be seen just, or even most importantly, as vehicles for civic or constitutional removal. Because they are consistently procedurally elastic, and because they facilitate appeals to a deinstitutionalized version of the people, constituent assemblies instead often operate as procedural vehicles for the consolidation and entrenchment of incumbent power. Thanks.
Thank you so much. And I encourage all of you to put questions in the Q&A. Let me start with a question for all of our panelists. Proponents of a constitutional convention are calling it a convention of the states. Is that an accurate depiction? Why or why not? And what difference does it make?
That is not an accurate description. There's nothing in the Constitution that calls it a convention of the states, and it wouldn't be controlled by the states. The delegates would be chosen in whatever manner the congressional majority that calls it decides. And one can easily imagine that if it is a very willful congressional majority after the midterm elections, that the representative of the states, supposed representative, may not reflect what the people of the states think. State governments have no formal role in this, and we can expect that the convention will be a puppet of whatever Congress calls it.
I'd add that I think it has to do, calling it a convention of the states has to do with, it's consistent in some sense with the anti-federalist proposals way back at the beginning, right? The idea was that we aren't really a single country. We should devolve power from the national government to the states. And some of the proposals related to, say, the balanced budget, which require, for example, the states to approve federal borrowing. There would have to be a majority of states that would approve if the federal government going into debt. That would dramatically change our ability to function as a single nation. But I think it all goes back to this in my view, misguided notion that the states are really the core of sovereignty, and the national government is something more like what we have with the Articles of Confederation.
Anyone else? Okay, thanks. Here's another question for all of you. To safeguard the Constitution, what are the most urgent priorities?
I'll talk about this. So I think that there are various priorities, and Carolyn, I think, highlighted a lot of them. They're more democratic in substance. So you're talking about gerrymandering, suppression of voting rights, things like that. There are some structural problems. We all know that the Senate is really problematic, both in terms of its own internal operations, i.e. the filibuster, but then also the fact that it's deeply unrepresentative. A state like California with 39 million people has the same representation in that chamber as a state like Wyoming with about 500,000 people. So we have some deep democratic problems and problems that are structural. I would also say that another problem is the Supreme Court itself. We're seeing an increasingly active Supreme Court. I think the term activist court was something that used to be thrown around by conservatives to be a pejorative, talking about what progressives do when they have control. Progressives have rarely had control over the courts in our history of the United States history. So it's kind of bizarre there. But the fact that we are seeing the court sort of undermine precedent. They're not going through the normal process of briefing and having arguments before they sort of let flagrantly unconstitutional laws on abortion stay in effect. The fact that they're doing an increasing amount of their work on this shadow docket, and the fact that, the lifetime tenure issue, which really, I think, facilitates these sort of spirals in terms of confirmation battles and gaming in terms of when justices and judges decide they're going to step down, if they decide they're going to step down, not to mention what happens in the political branches in terms of getting these ones on these judges and justices in the court, holding open seats for a year nearly, or pushing them through in 3 weeks. So I think we have a lot of deep democratic reforms we need to think about that are really pressing, and some of these are very, very structural in nature.
If I can add a very, very general gloss to what Wilfred said. The question was originally how do we save, or how do we redeem the Constitution? And it's worth remembering that the people who drafted the Constitution did the best that they could given the political science that was available at the time. And they were, in general, conscious of the limits of their own knowledge. And reading the Philadelphia debates about Article 5, one has the impression that they saw the need to learn and to revise understandings, institutions, and arrangements in light of learning that they expected to occur in the future. And so we do the framers of the Constitution a disservice, and I think we do the Constitution a disservice if we think about it as a project that was frozen in aspic at the moment of its creation, as opposed to a dynamic project that was informed by the very best political science of the day, and that ought to be thought through and illuminated by the very best of political and moral science that we have at our disposal today. I think that leads to many of the same conclusions that Wilfred described, but I hope it's a useful way of thinking about what does it mean to be faithful to the Constitution in light of the problems that he enumerated.
Thank you. No, that's right. And there are two paths in Article 5. One, a constitutional amendment path, and the other through a convention as well. So let me turn to some of the questions, other questions people have. Here is one from John Gray that he asked, could lawsuits affect how the convention is run? Or would courts say that it is what Frankfurter meant by the political thicket and dismiss the cases?
Go ahead.
Oh, no, after you, Carol.
Oh, I mean, I think this Supreme Court would say these are political questions and would bow out. It's hard for me to imagine them doing otherwise, especially after the opinion in Rucho, which was deeply misguided, but that's for another panel.
Yeah, so I think there is case law about some amendment battles. And typically the court does kind of take a hands-off approach. There's little contradiction between how they approach this, but they do want to keep it with the political branches. Now the question then becomes, who are these political branches? Is it Congress? Is it the states? If we're talking about this sort of convention of states, is it something else, right? So first there's that question. But then there's also just a question of these being cases of first impression. And when you have that means you only have the closest analogies to sort of drive your reasoning. But I don't think a court like this really cares. And I think this sort of goes to the point that Carolyn just raised. I think Rucho was an opinion where we had a lot of sort of support for establishing a standard for to prevent extreme political gerrymandering, but the court just kind of dispensed with it because they could. And I think increasingly what we're seeing is that this court is ready to dispense with a lot of things that we thought to be pretty stable in our law. And so when they're presented with something that is a complete novel question, I have no doubt that they would use these sort of constitutional hardball or strong arm tactics or what have you to sort of decide the case in the way that is most favorable to the side they tend to agree with.
Anyone else? Thank you for mentioning the Rucho case. It was the Common Cause v. Rucho case, and we took that loss very hard. I've been fighting it at the state level. Another question, some people have said that we need a constitutional convention to get rid of Citizens United and undo corporate influence in our democracy. Is there a way to narrowly focus a constitutional convention?
Unfortunately, there isn't. There's nothing in Article 5 that calls for a limited purpose constitutional convention. There's no authority for Congress or the states or anyone to limit its authority. The convention would control its own agenda, and there's every reason to believe that its agenda would follow the wills of the Koch brothers funded groups that are pushing it. Once the convention starts, it's pretty much all bets are off. The irony about this is that the very influence of big money, corporate money, in our politics is what makes an Article 5 convention so dangerous. Far from limiting the power of money in politics, it would probably entrench it. Right now, we're a few Supreme Court justices away from reversing Citizens United. But if we have a Koch brothers dominated Article 5 convention, it will be in the text of the Constitution and completely outside the Supreme Court's reach, barring yet another Article 5 convention.
Anyone else? Actually, I do believe, yep, go ahead.
Say, the Constitutional Convention in 1787 was supposed to be constrained, and we all still, that it didn't work. They were supposed to be proposing amendments to the Articles of Confederation, and instead they threw it out and started over. So it's hard to see how even explicit constraints are enforceable.
You know, this is another question we got from one of our viewers is you had mentioned the Koch brothers, but who are some of the interests who are funding the efforts to drive an Article 5 convention on a balanced budget or convention of states, for example?
Well, I believe one of the organizations that is pushing for this is ALEC, the American Legislative, I can never remember all of the words.
Exchange Council, yes.
Thank you. And they have in particular been pushing the requiring states to sign off on federal debt.
Yeah, and in addition to these sort of money backers, so the Koch brother industries or the Koch sort of organizations and ALEC, there are other names that were either more or less well-known sort of backing them. There's Mark Meckler, who was part of the Tea Party Patriots. There have been several governors or former governors, Scott Walker, I think Governor Abbott. So there are, you know, and there are sitting members of Congress who also back these efforts. So this kind of all leads back to the idea that if there are questions and these questions are kicked back to Congress and or the states somehow, because we don't have real guidance, there's no textual instructions in Article 5 itself, then you know, we can guess how that's going to go if it's kicked to these types of people to decide these novel questions.
Well, I'm afraid we're going to have to end it here because we are at the end of our evening. I want to thank all of our panelists who have talked to us about this real challenging issue. And I invite each of you as you leave tonight to think about these issues. I believe this is one of the most important issues and threats to our democracy that most people know very little about. And it poses an unacceptable risk to go through an Article 5 convention. I do believe Article 5's constitutional amendment still offers a path for strengthening our Constitution so it lives up to the promise of democracy. If you're a legal scholar who wants to learn more to educate your students, we'd love you to get involved. If you're a community advocate who wants to talk more about this at your next neighborhood meeting, we urge you to get more information from ACS. No matter who you are and where you are, you can get involved and make a difference in educating your fellow Americans about this real challenge that's out there to weaponize an Article 5 call. We see these efforts moving year in and year out and would like more people to get involved. The other thing I'll say as a group that works on this is that many people don't understand it and they are hungry for legal scholars and experts in this to share more about what they know. So I want to thank all of you for your discussion and your engagement in talking to people about this important issue. So thanks for joining us and good night, everyone.
Thank you.
Good night.